We will be discussing today the federal judiciary, the most powerful judiciary in the world. I hope you get the big picture in realizing that the way the Constitution is put together, it's really quite logical. For example, we've discussed Article 1, which is the what?
The
legislative. Back in 1787, when the Constitution was written, there were approximately 4 million people in the colonies. What's the first thing you have to have if you want to organize people? You have to have a set of laws. Who makes the laws? Legislature. Article 1 is legislative. Once you make laws, what do you have to do with them? Enforce them. So Article 2 is the enforcement branch, or the executive. Once you start enforcing laws, somebody's going to say, I didn't do that. Yes, you did. No, I didn't. Then let's go see the judge. And so Article 3 is judiciary, which is what will... This Constitution is so logical. There's only 7 articles in the main body of the Constitution, and we're on Article 3, which is the judiciary. So, beginning on page 569, how many have been to the Supreme Court building in Washington? A most interesting story behind not only the building, but the judiciary and its growth, and it's what we're going to talk about. Its power that it has today. In today's lesson, we are having no provisions, because everything I'm going to tell you is historical background which you need to know. Any constitutionalist needs to know how the power of the Supreme Court came about, both through the Constitution and through precedent. First thing we want to talk about is really a quote from Jefferson. You recall this, talking about this before, the chains of the Constitution. And I want you to turn to page 570 as I remind you of Jefferson's comment about confidence and jealousy. Do you remember that quote? Mm-hmm. And basically he said, government is not founded in what? In confidence. We don't just elect leaders and then say, do it and leave me alone. Jefferson, well, let's read it. Bottom of page 570, first column. He said, it would be a dangerous delusion were a confidence in the men of our choice to silence our fears for the safety of our rights. What's he talking about? Just having confidence that, well, our rights are going to be protected now that we have good people elected, so we won't worry about it. Jefferson said that's a dangerous delusion. That confidence is everywhere the parent of despotism. He says that's exactly what leads to despotism. Free government is founded in jealousy. You remember us talking about this? And not in confidence. It is jealousy and not confidence which prescribes limited constitutions to bind down those whom we are obliged to trust with power. That our Constitution has accordingly fixed the limits to which, and no further, our confidence may go. And then the famous statement, which is our discussion for today. In questions of power, then, let no more be said of confidence in man, but bind him down from mischief by the chains of the Constitution. You remember that phrase? Well, I want to ask again, what are the chains of the Constitution? They're outlined there generally on page 570 in the second column. What would you say the first thing to do if you want to put chains, symbolically, in a Constitution to bind people down so that they don't get more power than they should have? What's the first thing you need to do? You need to assign them only limited powers and say what? You can do this, 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 and this, and nothing else. Is that a chain?
Yeah.
Absolutely. Once you assign them limited powers, you need to separate those powers so that all the powers don't belong into one person or one small group of people. Remember, the founders said, if you have the power to make a law, enforce a law, and interpret a law, all in the same person, you've got a what?
Tyranny.
Tyrant. So you separate the powers. Is that a chain? Okay. How do you keep the powers separate? By providing checks and balances between the branches, between the divisions. And do the checks and balances have to stay vibrant and effective? Absolutely. Else the powers will begin to what? Come together, right? What's another chain of the Constitution? The fact that it's what? Written down. Remember, that was a weakness of Anglo-Saxon law, that it wasn't written. Write it down so that anybody can look at the limitation of power, the separation of power. All right, well, that's fine to say. You limit the power, you separate them, you provide checks and balances, you write it down. Is that all you need? What else do you need? Dr. Skousen says here, you need a guardian. What's that for? It's fine to have it all written down nicely, but if there's no one living who can identify when the chains of the Constitution have been violated, what good is it?
Supreme Court.
Do you understand? So somebody has to be the guardian of this thing. To say, oh, no, you violated that and that. You've gone over that boundary. You see that point? So, has to be a guardian set up. Now, I want to introduce to you two people who had different views on who's supposed to be the guardian. One of them, you might know, is Thomas Jefferson. And Jefferson said, well, it's very simple. All three branches should be the guardian of the Constitution. Do you agree with that? The legislative branch, the representatives of the people, should guard the Constitution. The President should guard the Constitution. The Supreme Court should guard the Constitution. That makes sense? Yeah, it does, doesn't it? And this was Jefferson's main thing. And the people themselves should be the guardian of the Constitution. Everybody should be the guardian of the Constitution. Jefferson was a great populist. He wanted to make sure all the people were involved. Then you had Jefferson's cousin. Who was that from your reading? John Marshall, who eventually said, and we'll tell you the details on this, that the federal judiciary, the judicial branch of government, is really the guardian of the Constitution. And therein you have, between two great men, a very different opinion about who is supposed to guard the Constitution, make sure everything keeps in balance. And that's what we're going to talk about today. Okay? So let's talk about how the Supreme Court under John Marshall evolved as the guardian of the Constitution. John Marshall wasn't the first Chief Justice, but he was the Chief Justice appointed actually by President Adams, who was president when? Just before Thomas Jefferson. So John Marshall is now the Chief Justice of the Supreme Court, and an interesting case develops, Marbury versus Madison. This is one of the classic cases that every constitutionalist has to know. Marbury was a person who had been appointed by President Adams to be a federal judge just before Adams left office. Well, the Federal Judiciary Act that was already passed into law said that the commission actually has to be delivered to the person in order for it to be effective. Well, when Adams left office, the commission had not yet been delivered. And so when Jefferson took office, guess what he did? He stopped the commissions on those judges, what was called midnight judges, because it was done at the last minute by John Adams. He stopped them from going into effect. In other words, he says, no, I want to appoint my own judges, not the ones that the former president has appointed. So Mr. Marbury filed suit against Jefferson's Secretary of State, who was James Madison. Hence you have the case Marbury versus Madison. Thing winds up in the Supreme Court. And it's kind of a touchy thing and a lot of detail which is explained in almost any American history textbook. But the upshot of the decision was John Marshall said that even though Mr. Marbury was entitled to his office, the procedure outlined in the Judiciary Act passed by Congress is unconstitutional. You see what that did? That's the first time the Supreme Court claimed to have what Marshall called judicial review. Review of what? What did Marshall claim to have reviewed? That's correct. Laws passed by Congress. And you have the Supreme Court then saying that a law passed by Congress is unconstitutional. That established a precedent and the doctrine of judicial review. And John Marshall said that is a prerogative of the Supreme Court. What do you think Jefferson said about that? He came unglued. We'll talk about that in just a minute. Where does John Marshall get this kind of thinking? Well, he says it's really implied in the Supremacy Clause. We haven't studied the Supremacy Clause yet. That's in Article 6. But that basically says that the Constitution is the supreme law of the land. Well, it's fine to say it, but who's going to enforce it? Who's going to decide if the Constitution takes precedent over any law? Who would decide that, John Marshall is asking. He says somebody has to be the final say. And it's got to be the Supreme Court as cases are brought to it. Does that make sense? Mm-hmm. Yeah, it does make sense. So what we've said here, Jefferson's logic makes sense, but so does Marshall's. And that was the real tug-of-war. And so Marshall said, all laws must be measured against the Constitution, and it is the prerogative of the Supreme Court, by implication in the Constitution, that the Supreme Court can declare a law passed by Congress to be in violation of the Constitution. That's the very famous case, Marbury versus Madison. And do you see a weakness there? Do you see a problem here?
Yes.
What would be a weakness? What's the problem you see here? Yeah, the major weakness in the whole thing is what if the Supreme Court imposes its will on the nation instead of the
people's will.
Constitutional will? In other words, what if they don't even think about what the Constitution says, they just say, this is what we think it ought to be?
Which it has.
Yeah.
Think that could ever happen?
It has.
It hasn't.
Yes, it has happened. See, this is the big problem with setting up a few people on the Supreme Court and calling them the ultimate arbiters of the law. And that's what Jefferson had a problem with, as we'll see here in a minute. Somebody says, well, there are remedies in the Constitution, are there not, if the Supreme Court gets out of line? What are some of the remedies?
Can you impeach the Supreme Court?
You can appoint new ones. What about that?
Only if
Forever.
Yeah, only if there's a vacancy, because judges are in there for life. What kind of a remedy is that? Jefferson would ask. What's another remedy? The Constitution actually says that Congress may restrict the certain jurisdictions of the Supreme Court. This really ought to be used more. It hasn't been used very much. Congress could actually restrict by law, the jurisdiction of the Supreme Court, meaning what kinds of cases it can hear. But they haven't done that. What's another thing that could be done to judges? You know this. We just talked about it. What is it? Impeachment. Impeachment. You can impeach him. Well, how easy is that? That's not very easy, is it? So, Jefferson would say there's really no remedy, no real tight remedy for a runaway judiciary. Is he right? Mm-hmm. Yes, he's right. Let's look at both of these men, Marshall and Jefferson. As I said to you, these men were cousins. They had both been trained in the law, Jefferson more than Marshall, by George Wythe, first law professor in America. They both had great reverence for the Constitution. They both considered the people as the ultimate authority. And they both felt that the role of government was to protect the rights of the people. What would you think about both of these men?
They're good men.
Yeah. They both pretty well got it right. And Marshall had had some experience that led him to believe you've got to have one final entity making some decisions to bring issues to a final, to finality, I guess we could say it that way. And Jefferson wanted to leave it a little more loose. And, okay, now I want you to turn to, I'm going to read some quotes here by Jefferson so that you make sure over on page 573, second column, next to the last paragraph. This is Jefferson. He says, the Constitution intended that the three great branches of the government should be coordinate and independent of each other. As to acts, therefore, which are done by either, it has given no control to another branch. What's he saying about judicial review? Constitution has given no control of one branch on the other. Checks and balances yet, but no control. What's he saying about judicial review?
It doesn't control.
It doesn't, it's not constitutional. See, this is Jefferson's position, okay, as we mentioned. Now turn over the page. 574, first column. Drop down to the quote there near the top. This is Jefferson still. He says, you seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed. You see Jefferson's, he's pretty straight here, isn't he? And one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. He says there's nothing special, particularly about the honesty of judges just because they're judges. They have with others the same passions for party, for power, and the privilege of their core. Their power is the more dangerous as they are in office for life and not responsible as the other functionaries are to the elective control. Do you think he's right? Yeah, he's got a good point here. Just because they're a judge. Now you think about this, folks. Here the Supreme Court in our day has been handing down decisions for decades. What makes 9 people on the Supreme Court any more honest, any more understanding as to the will of the people than the legislature? I can't really figure that out either. So you have to agree with Jefferson. See that? Okay? Jefferson felt that strong government, particularly in the Supreme Court, was a threat. And Marshall felt that someone had to ultimately interpret the Constitution. You got to have somebody to make a decision. What if you didn't? Then it wouldn't be brought to a final situation, and that would be probably confusing. So, who won out? Marshall finally won out. There's a couple of clauses in here that I've mentioned. One of them is the supremacy clause. The other is the binding clause. These are all words in the Constitution. Somehow, somebody has got to declare what is supreme. And Marshall felt like that would be the court. And as I said, Marshall felt like by having the court do it, you would bring all cases to a final decision so it could be done and over with. Does that make sense? Yeah, that's kind of logical too. Otherwise, you might have a Congress making a decision today and the next Congress may make another decision. In other words, it wouldn't never come to a final decision. So, now we want to get into, all right, once we've established, I should say, the fact that the Supreme Court has the power of judicial review, if not in the Constitution, at least now by default. What's the next big question? We've touched on this. What's the next big... If you're going to give the Supreme Court the power to decide what is constitutional and what isn't, what's the big question? What? Yeah. How do you interpret the Constitution? Wouldn't that be the next logical thing for the Supreme Court to ask themselves? Okay, now that we have the power to do it, how are we going to do it? What guidelines are we going to use? This is where it gets most interesting because there's 3 quotes here in the book that we're going to look at, starting on page 576, that basically says, well, it's natural. You interpret the Constitution the way the writers of it intended. Is that logical? I mean, you and I would think that. Let's go to page 576. First 2 quotes from Jefferson, top of the first column. He says, "The Constitution on which our Union rests shall be administered by me according to the safe and honest meaning contemplated by the plain understanding of the people of the United States when?" What does it say? At the time of its adoption. You mean not 200 years later? No. If you're going to say this is what the Constitution means, are you going to take the meaning from somebody 200 years later? Does that make sense? No. If you're going to say this is what the Constitution means, you got to go back to the time of its adoption and see what they meant who wrote it. Is that logical? Sure. A meaning, he says, to be found in the explanations of those who advocated, not those who opposed it. These explanations are preserved in the publications of the time. Can you think of one? Federalist Papers. You go to the Federalist Papers that clearly explains a great number of items in the Constitution. A lot of the quotes that Dr. Skousen put in this book are from the Federalist Papers. And so, if you had a question about the meaning of something in the Constitution, you'd want to go to the Federalist Papers. You'd want to go to ratification debates. When the founders who adopted the Constitution were involved in ratifying it, they made some great arguments for it. And when questioned about some of its provisions, they explained it. See, those are the things that you'd want to go to. Well, look at the next paragraph. On every question of construction, which is meaning, let us carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates. And instead of trying what meaning, get this, folks. Are you following me here? Yes. And instead of trying what meaning may be squeezed out of the text, what's he implying here? Instead of trying to say, well, I think it means this, and just, really go out on a limb. Instead of trying to squeeze something out of the text or invent it against it, conform to the probable one in which it was passed. Is that not logical? That's what Jefferson says. Look at the bottom of the first column. This is Chief Justice Taney, a later Chief Justice. He said, it, the Constitution, speaks not only in the same words, but with the same meaning and intent with which it spoke when it came from the hands of its framers, and was voted on and adopted by the people of the United States. Any other rule of construction would abrogate the judicial character of the court and make it the mere reflection or reflect the popular opinion or passion of the day. Hello? Is this not what's happening? Mm-hmm. He says, if you don't go back to the original construction, then all you have is a Supreme Court that just reflects the popular opinion of the day, and then you have to ask yourself what? Then why have a written Constitution? Does that make sense? Why even have it? Why even honor it, the document that was written 200 years ago? If all you're going to do is take the popular whim of today and say, this is what it means. Well, now, probably the most famous quote from Jefferson. This might scare you a little bit, but I want you to think through this and see how real this is today. And this is the bottom of the second column on page 576. This is Jefferson. He wrote this in 1821. This is 5 years before he died. Would have been, 13 years, 12, 13 years after he was president. He wrote this. It has long, however, been my opinion, and I have never shrunk from its expression, that the germ of disillusion of our federal government, what does that mean? Germ of disillusion of our federal government. What does that mean?
Even the slightest bit.
The beginning of the fall of our federal government, right? The germ of disillusion of our federal government is in the Constitution of the Federal Judiciary. Who's Jefferson going to blame here for our federal government falling apart? Federal Judiciary. Let's see what he says. An irresponsible body, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction, until all shall be usurped from the states, and the government of all be consolidated into one. What's he saying might happen? That the Supreme Court may substitute its will for the founders' will so much that all the power will be given to the federal government. Do you think that might happen? Think that could happen?
Yeah.
Think that has happened?
Yeah.
Absolutely. Mostly by judicial decree. Then what does he say? To this I am opposed, because when all government, domestic and foreign, in little as in great things, shall be drawn to Washington as the center of all power, it will render powerless the checks provided of one government on another, and will become as venal and oppressive as the government from which we separated. What's he saying? Could get as bad as King George if we're not careful. And he says, if it ever happens, I think it may very well happen because of the federal judiciary. So, that's pretty incriminating, isn't it? That's his prediction. Okay, let's turn our attention to, on page 577, under the heading Nationalizing Criminal Justice. How has the Supreme Court actually done what Jefferson said they might do? In 1925, in the Gitlow case, the Supreme Court ruled that all of the prohibitions of the Bill of Rights now apply to the states and local governments. Well, what provisions are there in the Bill of Rights? What prohibitions? That Congress can't do what?
Make any rules regarding religion.
Make a rule, make a law regarding prohibiting or establishing religion. That Congress has to stay out of matters concerning speech and press, right? And a whole bunch of other things in the Bill of Rights. And what happened in see, those were all original prohibitions on Congress, federal government. And in 1925, the Supreme Court said, all of those prohibitions now apply to the states and the cities and the counties. So you want to put the wise men on the butte during Christmas time? What's the cry? You can't do that because it's a violation of the First Amendment. Do you see how that now not just applies to Congress, it applies to the states and the local governments since 1925. And because of that ruling, who has the enforcement power when those kinds of rights are supposedly violated? Federal government. Do you see where a huge transfer of power is given to the federal government? Just in that one case. That's what happened. Was Jefferson's prediction right? Absolutely. Civil rights have always belonged to the states and local governments. But after 1925, you feel like your civil rights are violated? Guess where you can file suit? Federal court, and have the whole weight of the federal government. Isn't that amazing? Really predicted. That's how the federal government nationalizes crimes, is they take those kind of jurisdictions. Jane?
Can you take the government to court?
Can you take the government to court? Absolutely.
Signing stuff.
Sure.
He's allowed to sign, but he's not allowed to sign without the consent of the state.
Yeah. Of course. You see, the court is supposed to be the guardian of the Constitution. So if an American president violates the Constitution, you ought to be able to go to a federal court and get remedy and restore the constitutional balance. That has been tried. Guess what? The Supreme Court doesn't read the Constitution anymore. They have, and I'll show you this here in a minute, they have totally substituted their will and what they think it should be today for what the founders said it should be. So all these chains of the Constitution, the separation of powers, the checks and balances, no longer really enforced, because we're not going back to the original thinking. Okay? So yeah, it's been tried. But that's the frustrating thing when you say, well, what can we do then? Well, as I've always said, what's the answer? Education, vote in better people. You got to do it. Okay? This is an interesting point. What are the qualifications for a Supreme Court justice in the Constitution? What would you say?
Old.
Huh? Old? Actually, there's no age qualification. Actually, there is no qualification. None. You don't even have to have read the Constitution. Does that surprise you?
I think there should be some limitations.
No age limit. We've had Supreme Court justices that have stayed there for so long, they've become senile and hardly able to function. Anyway, I want to describe to you a situation that happened in these years, 1954 to 69. This is the Earl Warren Court. Do you know that there was a time during this court that no judge, not one judge, had had prior substantive judicial experience? Now, wouldn't you think that an appointment to the Supreme Court of the United States would require a person having had, or you would want a person to have had a little bit, at least, of judicial experience? Somebody who sat on a bench before, either in a state court or a lower federal court? Wouldn't you want them sitting on the bench of the Supreme Court of the United States? Guess what? There was a few years during the Warren Court where nobody had had any substantive judicial experience. What does that mean all these appointments were?
Citizens?
Political. Including the one of Earl Warren. You know what Earl Warren had been? Governor of California. Appointed to the Supreme Court. Is it any wonder then that out of the Warren Court you get cases like what?
Marbury, Madison.
Well, Marbury versus Madison was way back early, but you get cases like no prayer in school, no prescribed Bible reading in school. In other words, a lot of the religious aspect of public education was taken out. Just after this was Roe versus Wade in 1972. Mostly by the same people were on the Warren Court. I mean, you just get landmark decisions that completely reverse or change public policy. You get people on that court that don't have any experience as judges. Well, yes, any one of you. You don't have to have a law degree. Most of them do, and I presume all of those do, but I mean, you need to be experienced in judiciary. Yeah. How much they get paid? A lot, and then when they retire at full pay. It's in the six figures. I can't remember exactly how much it is. Yeah, you can when you retire. If you retire, some of them just die in office, but if you retire as a Supreme Court justice, you retire at full pay. Is there any way to remove a Supreme Court justice? Is there? You can impeach him, but you know that's pretty. What did Jefferson call it? Impeachment. He says, "For impeachment is scarcely a scarecrow." What does that mean? You're not going to scare anybody into doing the right thing by saying, "I'm going to impeach you." See, that's scarcely a scarecrow, right? Because it's so difficult. So it's no threat. Anyway. Let's talk about the 4 stages of judicial rule that our Supreme Court has gone through. The first stage would be, what would you think it would be naturally? Right after the Constitution was written. What he terms national supremacy. In other words, judges used the Federalist Papers and the words of the founders to interpret questions that they may have of the Constitution. What do you think of that? That's what you should do, right? You got a question about what lawmakers meant when they wrote the Constitution or wrote the law, then go back and read the discussion they had. That makes sense, doesn't it? The next one, second phase from 1835 to 95, we still pretty well held to the original interpretation, but theories began to be developed. And the theories were still mostly in line with constitutional provisions. But the words of the founders were beginning to be ignored, forgotten. And that was that provision. The third one is called judicial supremacy. I gotta refer you to this quote. This blows your mind here. Top of page 578, second column. I want you to go down 1, 2, 3, 4, 5, 6 lines. This is the Chief Justice Hughes who said this, if you can believe this. We are under a constitution, but the constitution is what the judges say it is. And you have to say, whoa. Do you see the arrogance here? Oh yeah, we have a constitution. We're under the constitution. But the constitution is what we say it is. So you have to ask what? Why have a constitution? Why delineate power? Why have checks and balances? Why put anything in writing if you're going to say it's what we say it is? And every new judge has his own interpretation. Can you imagine a Chief Justice saying this? It's what we say it is. It's not what the founders said it is. It's what we say it is. Kind of scary, isn't it? What would you guess the fourth stage is? I mean, how can you get worse than this? I think you hinted at it, James. Completely out of control stage, which is what we're in now. If you take a case to the Supreme Court, you would think you could go to the Constitution and perhaps find out how they're going to decide based on law, wouldn't you? Guess what? Can't do that anymore. You got to look at, and lawyers do this, you got to look at every judge on the Supreme Court that's currently there. And you have to psychoanalyze each one of them to see, let's see now, what's their political philosophy? What have they done in the past in decisions? Give me a break. What kind of law is this? That's what you have to do. Totally out of control. What's the remedy? Thomas Jefferson suggested one. It's known as the Jefferson Amendment. It's on page 579. I'll just tell you. Jefferson said, I mean, he was really anxious that we correct this weakness in the Supreme Court. And he said, I think we ought to have an amendment to the Constitution which would allow Congress to overturn a Supreme Court decision by a 2/3 vote. What do you think? Does that do it? See, that's an additional check. It's not impeachment, but it's the threat of the Supreme Court will always know that the representatives of the people can overturn a decision by a 2/3 vote. So that's kind of an interesting proposition called the Jefferson Amendment. So the Supreme Court says, yeah, you can burn the flag. You got freedom of speech. You remember that when that happened a few years ago? And everybody in Congress was upset and they wanted a constitutional amendment to change the Constitution so the Supreme Court couldn't say that. That is so hard to do. It's like impeachment. All Jefferson is saying, just let them overturn. Let the representatives of the people overturn a decision of the Supreme Court by a 2/3 vote. Huh?
Isn't that the same vote that is required for an amendment to pass?
Yeah. Yeah, same vote that's required an amendment to pass, but it doesn't require it to go out to the states and all that.
Yeah.
Anyway, that is the history of the Supreme Court. And in our next lesson, we will actually go through the powers and the kinds of cases that the Supreme Court can adjudicate. Thank you very much.